Hi, I'm Dan Covington. I'm an estate planning attorney, so I help people conserve their assets and get them where they want them to go. Today we're going to talk about a little more broad topic. Sometimes we get down into the weeds a little bit and a lot of legal details, but we're just going to talk about the two main ingredients, things you really need in your estate plan. These are going to be kind of your main instrument of conveyance, so your trust or your will. And the other thing you may not be familiar with is the durable power of attorney. So let's go ahead and start with that. That's a little less known document. The durable power of attorney is really a way maybe to save your bacon, right? So we talk about conserving assets. What a durable power of attorney can do is allow someone, in that document you're going to nominate someone who can act on your behalf. So pretty simple document to put together, doesn't take much, but if you came to the point in your life where you had some kind of dementia or Alzheimer's, or in any respect were just not competent or able to handle your own affairs, someone appointed in your durable power of attorney can act on your behalf. That may not sound like a lot, but if you don't have a document like that, someone, a trusted person in your life, is going to have to go to court in the event that you're unable to act on your behalf anymore. Take care of your own affairs. They're going to have to go to court to be appointed as what's called a guardian conservator. A guardian is a person who looks after your health and your person. A conservator is a person who looks after your assets and your finances. It's within the probate code, so it's a little bit of a lengthy process. It can be, and it's if you want to conserve your assets, use them efficiently and wisely, you don't want to be going to court when you could have, during your well time, appointed someone as your power of attorney so they can act on your behalf but not against your competent wishes. So these durable power of attorney is kind of basically half of the important part of an estate plan. The other part being, as you know, a trust or a will. If you're not familiar, a trust, essentially you convey assets into your trust during your life. So a probate court need not do so. You avoid probate later. And then on your passing, if there's two of you, your trust can still be available for your spouse all during their life. And after the passing of the second of you, then your trust can either be managed by your trustee for a time. Say you want some kind of delayed, maybe you set up a college fund for someone, or maybe you want someone to get funds at age 25 or 30 or 35. Your trust can be managed for a time, and then it can be privately administered by your trustee. The assets can be distributed without court supervision, without court orders, without publishing notices in the local newspaper. I guess you can tell by the way I talk about it, it's really a great way to convey your assets. The other piece, if you didn't do a trust, the other piece you might need is a will. And what a will does, you don't convey assets into your will per se. During your life, your will, you're certainly familiar with how a will works. You name maybe all my assets go to my spouse. If my spouse doesn't survive me, then divide it among my children. Something as simple as that. Again, it's a little more simple to put together now, but then when you pass, a will to be effective does have to be probated, meaning it doesn't really have power unless it goes to the court, so it needs to be offered for probate. There's publication notice requirements, creditors notice, a 4-month period for creditors to respond and file claims. You are looking at very commonly a 6-month, maybe 6-month plus process with attorneys and a court to supervise the administration of your estate. I'm not knocking this process the process works, and there are several different kinds of processes to make it flexible for different kinds of estates. But I'm partial to a trust because things can be handled privately, and it's kind of already taken care of, and you don't need someone to look over your shoulder the other time. You've set out what you want to do, and you've named a trustee or trustees that you want to take care of things. So again, maybe it ended up, I can't help myself, it ended up being a little more detailed, but this today was just a broad picture of, again, two basic things you need in an estate plan. I think everyone needs a durable power of attorney because you've got to take the simple step to take care of things in case something goes wrong, and it's just a smart way to conserve assets. The other piece is your instrument of conveyance. So when you pass away, how are your assets going to be distributed to your loved ones, to your charities, to those who want you want to name as beneficiaries? I hope this helps you out. Again, I'm Dan Covington. I'm an estate planning attorney. I can always help you get your affairs in order, as they say. And you can always find me at estateplankansas.com.